Hello students, welcome to Thakur Vidya Mandir High School and Junior College. Today we are going to start with the part 5 of chapter 4, Business Services. We are going to start today the topic known as insurance. In this topic, we are going to learn the meaning and some basic terms which are used in the insurance and what are the principles of insurance. First, we will start with the introduction or meaning of insurance. Insurance is a means of protection from financial loss. It means if there is a financial loss, then we can try to protect us by recovering the money from insurance service. It is a form of risk management primarily used to hedge against the risk of contingent or uncertain loss. It means if there is a certain uncertain loss, we can try to protect us by claiming the money to the insurance company if we had insurance for that particular purpose. Insurance is a claim between insurer and insured, whereby the insurer agrees to compensate against the loss. The insured has to pay certain fixed sum of money on timely basis to the insurer. So students, here you get some terms which is difficult to understand, that is insured, insurer, that is nothing but the person who takes out the policy, that is the normal person, policy holder, and another insurer, it means any of the insurance company. That all the things we are going to learn in some basic terms in details. Here you can see the new insurance, that is New Assurance Company Limited logo is there, and another is for the Life Insurance Corporation of India, which people used to take out for covering their risk of life. Some basic terms in insurance we are going to learn. First is the insured, the person who is protected against certain losses. Insured is known as assured in case of life insurance contract. Students, remember this technical words: insured, assured in case of life insurance contract. He is also known as policy holder. Second term is insurer, the firm or persons who agrees to compensate the insured against losses for a consideration. It means the firm or person who agree to give the money to the insured, that is policy holder, against loss for a consideration, that is for a money. Insurer is an assurer in case of life insurance contract. Students, one more thing you have to remember, that is insurer is known as assurer for the life insurance contract because he is bound to get the sum assured on the maturity of the policy. That is, if any of the policy holder is having the policy for 5 years, then till 5 years, if that person is alive, then after completion of the 5 years becomes the maturity date or maturity of the policy, then that person will get the money on that maturity of the policy. Or if the person is dead, then the nominee will get the sum assured on the death of the policy holder. Next term is the premium. The consideration for which the insurer agrees to insure the insured. It is paid by the insured to the insurer. That is, it is paid by the policy holder to the insurance company. That is, every year they pay the money, that is, they pay the premium to the insurance company. Next term is the policy. The statement of contract between insured and insurer. That is, it is a contract or the bond between the policy holder and the insurance company. It contains the terms and conditions of the insurance contract. Next term is the claim. Claim is the demand made by the insured to the insurer to compensate the loss occurred due to mishap. That is, it is a claim or the demand made by the policyholder to the insurance company to compensate the loss which occurred to the policyholder. Next term is the proposal. Proposal, it is a written request made by the insured to the insurance company to issue an insurance policy. If it means any of the person wants to purchase a policy, insurance policy, he give the written request to the insurance company. Next term is subject matter. Subject matter refers to the subject or entity, that is, the policy is for what purpose? For the life, for the property, cargo, ship, which is insured, against which the policy is taken. Students, now we will move further with the topic known as principles of insurance. There are the 7 principles of insurance which we are going to learn one by one. So here we start with the first principle known as principles of utmost good faith. It means there should be the proper good faith between both the party, that is the insured and insurer. In all type of insurance contract, both the party must have utmost good faith towards each other. It means both have faith for each other, both should have trust for each other. Insurer and insured must disclose all material fact clearly, completely and correctly. It means whatever there is the fact, whatever there is the information, that information should be disclosed by both the party, that is the insurer and insured. Policy holder and insurance company both should disclose all the information. Insured must provide complete, clear and correct information of the subject matter of insurance to the insurer. That is, the policyholder should provide all the detailed information to the insurance company. Insurer must also provide related information regarding terms and conditions of the contract. Failure, it means if failure to provide complete, correct and clear information, it may lead to non-settlement of claim. It means further you will not able to settle the claim if you are going to claim it to the insurance company. Students, for example, Mr. A has not provided information regarding his heart surgery at the time of taking policy. Mr. A is the policy holder. He already done his heart surgery and he went to take out the life insurance policy. But at the time of policy, he didn't mention about his heart surgery. After his death, insurance company comes to know about the information as Mr. A has not provided clear and complete information at the time of taking the policy, so insurance company can refuse to compensate to his family members. So that's why it is there that always you should provide correct and clear information. Second principle is principle of insurable interest. Insurable interest means some financial interest in this subject matter. For whatever matter you took the insurance, in that matter you should have some financial interest, that is some financial benefit. Insured must have insurable interest in the subject matter of insurance. Insurable interest is applicable to all insurance contract. It is said that insurable interest in the subject matter where the existence of that subject matter put the insured in financial benefit. Non-existence of subject matter put him into financial loss. For example, a person has insurable interest in his own life and property. A businessman has insurable interest in the goods he deals and in the property of business. In life insurance, the insurable interest refers to life insured. Insurable interest must exist at the time of taking the life insurance policy. In fire and marine insurance, the insurable interest must be present at the time of taking policy and at the time of occurrence of loss. Third principle is principle of indemnity. Indemnity means a guarantee or assurance to put the insured in the same financial position which he was immediately prior to the happening of uncertain event. It means before occurring of the loss, whatever is the position of the insured, that is the policy holder, indemnity principle try to give you the guarantee or assurance to put that person in the same financial position. This principle is applicable to fire, marine, and general insurance. It is not applicable to life insurance as loss of life can never be measured in monetary terms. In case of death of insured, the actual sum assured is paid to the nominee of the insured. Under this principle, the insurer agrees to compensate the insured for the actual loss suffered. The amount of actual compensate is limited to the amount of assured or loss, whichever is less. For example, students, if the property is insured for 2 lakhs, but that property is lost by fire, the amount is 1 lakh, then the insured can claim compensate of rupees 1 lakh only because the loss occurred due to the fire is of rupees 1 lakh, though the property is insured for rupees 2 lakhs. Fourth principle is Principle of subrogation. This principle is applicable to all contracts of indemnity. In this principle, after the insured is compensated for the loss due to the damage of the property insured, then the right of the ownership of such property passes on to the insurer. That is, after the policyholder will get the money for the loss, then whatever the property is remain, that property will be taken by the insurance company. Now the insurance company will become the owner of that damaged property. This principle is applicable only when the damaged property has any value after the event causing the damage. Students, for example, Mr. A owned a two-wheeler. The vehicle was stolen and subsequently Mr. A filed a complaint in the police station. Upon receiving a report from police, the insurance company compensates fully Mr. A for the loss of the vehicle because Mr. A has already took the insurance for the vehicle. Later on, the stolen vehicle was recovered by the police. In this situation, the owner of the vehicle does not have any claim over the vehicle as he already subrogated, that is, transferred the ownership right of the vehicle to the insurer, that is, to the insurance company. Now the insurer gets every right to sell or to scrap the said vehicle, that is the motorcycle, because Mr. A already got the amount from the insurance company. Now insurance company will have all the right on the motor vehicle. Next point is the principle of contribution. This principle is applicable to all contracts of indemnity where the insured has taken out more than one policy for the same risk or subject matter. So many of the time, students, people used to take the policy from many insurance company for the one property. So we are going to learn that example in this principle. Under this principle, the insured can claim the compensation only to the extent of actual loss either from one insurer or all the insurer. If the one insurer pays full compensation, then the insurer can claim proportionate amount from the other insurers from whom the insured has taken policy. That is, if there is the loss, then one insurance company pay the money, full amount of money, then he will recover the proportionate amount from the another insurance company with whom the policy holder has taken the policy. For example, students, Mr. A insures her property of rupees 2 lakhs 50,000 with two insurers, with T insurance company for rupees 1 lakh and R insurance company for rupees 1 lakh 50,000. If Mr. A property is destroyed and the loss is 1 lakh 20,000, then both insurance company will contribute actual loss, that is the 1 lakh 20,000. In that case, T, that is the T insurance company, will pay 48,000 and our insurance company will pay 72,000 because the insurance company had covered the 2/5 of the property value and our insurance company had covered 3/5 of the insurance, that is the property value. Sixth point is the principle of mitigation of loss. Insured must always try to minimize the loss of the property in case of uncertain events. Mitigation, it means try to minimize the loss. The insured must take all possible measures and necessary steps to control and reduce losses. It is the responsibility of the insured to protect property and avoid loss. For example, a house of Mr. Jayant is on fire due to electric short circuit. In this case, Mr. Jayant cannot remain passive and must try his best to save his house from fire. Mr. Jayant must be active and cannot watch his house burn just because house is insured. Next principle is principle of CAUSA-PROXIMA. Principle of CAUSA-PROXIMA means when a loss is caused by more than one causes, then proximate cause, that is the nearest cause of loss, should be taken into consideration to decide the liability of the insurer. The property is insured against some causes and not against all causes. In such a case, the proximate cause of loss is to be found. If the proximate cause is the one which is insured against, then the insurance company is bound to pay compensation and vice versa. For example, a house was insured against the risk of theft. There was theft in the house, and before leaving, the house was set on fire by thieves. Now there are the two causes of loss, theft and fire, and the nearest cause of loss was fire. As the house was insured against theft and not by fire, the insured will not get any compensation from insurance company for the loss by fire, but he will get compensation for the property lost by theft. Thank you, students.